the Executive Director, Management and Staff of the Institute for Democratic Governance, IDEC. I warmly welcome you to this policy dialogue, which is themed Effective Constitutional Amendment, the Necessity of Legal and Institutional Safeguards. We'll get a bit more into the detail, but for now, I'd like to inform you that if you want to use the restroom, it's to my left. It's the building, which is the annex. You go quietly through the back door, and then you take your left, and the restroom is right there. You wouldn't miss it. I am Patrick Richard Okine, and a member of staff here at IDEC. Distinguished ladies and gentlemen, this event or this program is done as a collaboration between the Institute for Democracy and Oxfam, our development partners. Now, why are we here? We're here to deliberate and to discuss a very important issue that's being a debate all around for many years. And I say many years because issues relating to the Constitution is always so dear to our heart because it shapes our governance system, our governance structure, and how we relate to each other in terms of moving this country forward. I'd like to say that last year, in January last year, you would recall that the President established the Constitutional Review Committee, the CRC, under the chairmanship of Professor Henry Kwesi Prempeh. And they were given a mandate, 6 months mandate, to come out with recommendations on the reviews of previous constitutional reforms that needed to be implemented, and to see how they could bridge the gaps, and to come out with reports or recommendations that would deepen or strengthen our democratic. Now they requested for an extension, and on the 22nd of December last year, they submitted their recommendations or reports to the government. Then again, you would recall that in 2010, during the President Mills era, he also set up the Constitution Review Commission. That was a commission. And then they submitted their report or recommendations the year after, and the government further established the Constitutional Review Implementation Committee, Constitution Review Implementation Committee. Now, they came out with about 97 recommendations needing amendment. About 56 of them were non-entrenched, and about 41 were entrenched. And the entrenched provisions meant that we needed to go to a referendum to decide, to amend the Constitution. That was going to be done by the citizenry. The non-entrenched meant that Parliament was going to deliberate and then pass, the law regarding their amendments. Now, after President Mahama left office, we had President Nana Akufo-Addo take over. And in 2003, he also established a Kasiti committee that was established by the Minister for Parliamentary Affairs in the person of Honorable Oseche Mensah Bonsu. And they also came out with about 15 recommendations. Now, what has been the challenge is the implementation of all these recommendations or reports by our committees. You would understand that there is a pattern of constitution review committees and reports from implementation committees. But that seems to be stalling, and we haven't been able to move forward on these proposals or recommendations that are made. What is the problem? What is the cause? All of us do agree that matters relating to the Constitution are so dear to our hearts, and yet we're not moving forward with the implementation. So how do we address these? Today we have in our midst some experts. We do have a constitutional and law expert to give us a presentation on the safeguards for these legal issues. How can we amend certain aspects of our Constitution to take care of these lapses so that we can move forward and have the necessary reforms that we're all looking for? We also do have a governance expert, and then we have another expert, from the women's advocacy side. And so we're in a very comfortable place this morning with our experts, and would like to move straight on. But before I invite our first key presenter, I would like to take a message from our development partners. And to do us the honors is a representative from Oxfam, and he's in the person of Mohammed Mahmoud. Please put your hands together for him.
Thank you. Good morning, everyone. I'm happy that course established. So I'm just comfortably proceed. Having said that, I think it's good to recognize some individuals that have made a significant impact in our lives, and one of them is Prof. Jonah. Your teacher is always your teacher. Prof. Kwesi is also here. Let me say that I'm happy and honored actually to be given the opportunity to share some remarks, important policy dialogue on legal and institutional safeguards for the effective implementation of constitutional reforms in Ghana. I do this on behalf of my country director, Mr. Mohamed Anwar Adam Sadat, and Oxfam in Ghana generally. I want to start by being very candid, by saying that Ghana does not suffer from deficit of constitutional ideas. We suffer from deficit of implementation. Over the years, reform efforts have produced thoughtful recommendations, yet too often they stall at the point where law must confront power. This exposes a central weakness, and that weakness is our legal safeguards are frequently sound on paper, but fragile in practice. As observers of democracy and governance in the country, I'm here to share with us just 4 key observations. The first is that we have observed a persistent gap between constitutional intent and enabling legislation. This is because there has been delays, selective adoption, or if you like, dilution of reforms through ordinary laws, which normally undermines transformative purposes of constitutional reform. The second observation is that our institutional independence remains contested, in that bodies expected to enforce reforms are sometimes constrained, whether through political pressure, limited resources, or sometimes even the appointment process is opaque. But without credible autonomy and safeguards, the process becomes symbolic rather than functional. The third one is that we have observed that public engagement is often episodic rather than sustained, in that citizens are mobilized during reform debates, but sidelined during implementation. This weakens ownership and reduces pressure for compliance. The final one we have observed is that there's political incentive to not always align with reform outcomes. But until implementation is made politically costly to ignore and politically beneficial to uphold, progress will remain uneven. Let me conclude by saying that achieving meaningful constitutional reform in Ghana demands a holistic approach, one that integrates sound legal design, strong institutions, active citizens engagement, and unwavering political commitment by our politicians. To achieve effective implementation, constitutional reform implementation, we think that we must move beyond design to discipline, enforce timelines, insulate institutions, and empower citizens to demand accountability. It is on this basis that we think this platform is appropriate and also timely. So thank you so much. These are the few comments that we have as Oxfam and as people who sit and observe what goes on in our political system. Thank you.
Thank you very much, Mr. Mahmoud. Representative from Oxfam was grateful for that insightful message to us. Distinguished ladies and gentlemen, I'd like to move on to the next item on our program, which is the presentation on key considerations in constitutional amendments, and that's entrenched versus non-entrenched provisions, amendment sequencing, referenda, and legal timelines. You would agree with me that there are a number of challenges. As I indicated, we had about 97 recommendations by the Constitution Review Implementation Committee, and thereafter we also had the CASATI committee, the consultative committee, which also came out with about 14 recommendations. So we have in all these recommendations, they're very fine, but they're still kept on the shelves. How do we safeguard these? How can we create binding legal mechanisms to compel implementation? And should reform processes be time-bound by law? What role can the courts realistically play? And can we create legal safeguards that would make abandonment difficult for us? It is and belief that the outcome, or at the end of this program, would have outcomes that would stem the tide of these constitutional implementation processes that are stalled for our democratic governance. And on that note, I would like to introduce our key presenter, and he is someone who doesn't need any real introduction. He actually sent us a very brief profile of his, and with your kind permission, I'd like to read it out. And he's Professor Kofi Kwasiga. He is a retired professor of the University of Ghana School of Law and a former dean of the school. His teaching and research interests include constitutional law, human rights, international humanitarian law, jurisprudence, and alternative dispute resolution. He was a Fulbright scholar and a MacArthur Foundation visiting scholar. He had consulted for UNDP, UNICEF, and others. He was a former president of the Ghana Association of Certified Mediators and Arbitrators. He was for several years a member of the General Legal Council. He also served as a member of the advisory board of the Ministry of Justice. He had served as the Ghana National Reporter on the Constitution of Ghana for the Oxford Project on Constitutions of the World and a member of the Stellenbosch team on constitutional law in Africa. He's a member of the International Consortium on Law and Religion Studies, as well as the president of the African Consortium for Law and Religion Studies. He is a fellow of the Ghana Academy of Arts and Science, and I am delighted also to say that he's a member of the panel of experts for the Institute for Democratic Governance. He's worked over the years with us in shaping our documents, our policy briefs, and so on. With a resounding round of applause, could you please put your hands together as we welcome Professor Kofi Kwasiga.
Thank you, Okan. And good morning, distinguished invitees and colleague panel members. I'm so very much interested in the comments of the representative. Those were very incisive comments. Yes, indeed, it appears we are becoming so much interested in amending the Constitution. And there seems to be some pressure on almost every administration to want to bring about some amendment. We had it in 1996 when Rawlings was there, and then the late Atta Mills came in, and then President Kufuor, I'm not sure he initiated anything. Then Nana came in, and then here we are. So what could be the issue? If you ask me, which is not before us now, I would say it is all because of dissatisfaction with governance. Otherwise, we wouldn't be having this recurrent exercise of wanting to amend the Constitution. To me, it has to do with dissatisfaction with governance. And when it comes to these matters, I'm a pessimist that no matter what you do with the Constitution, if the people are not happy with governance, they will always ask for amendments. Yes, we can amend this constitution today. Tomorrow, if they are not happy, they will ask for amendment. You can be sure of that. But anyway, as I said, that's not before us now. What is before us now is how to ensure that the CRC2 report is implemented. My brother, I presume that is the... Oh, I'll limit myself to that. How can we ensure that this constitution now review process succeeds and is carried forward? In order to move fast and not to digress, let me read a little bit fast. Now, a constitution is generally intended as the supreme law of the country. Philosophically assumed to have derived its authority from the sovereign will of the people. To protect its origin, therefore, the Constitution itself vests its existence in the will of the people. This will of the people is a shield against the will of some authoritarian or even an unquestionable majority in government. It is to guarantee the strength of the Constitution that some of its provisions that are considered fundamental are entrenched to various degrees to protect them from being easily altered by some whimsical person in power at some particular time. These provisions are entrenched through subjecting the amendment to the overall will of the people themselves and not through some representatives in parliament. At the same time, the Constitution does contain provisions that are not so fundamental for its own existence, but are considered so important as to be given some protection above ordinary pieces of legislation. These become the non-entrenched provisions. As expected, these two general categories of provisions will be subjected to different amendment procedures reflective of their considered importance. Now, with this background, let's take a look at the CRC2 report. If I say CRC2, I'm referring to the current report. So let's look at take an overview of the CRC2 report. The report is structured under 9 first areas. The first one has to do with the presidency. Looking at the powers of the president, which they consider to be excessive, and therefore thinking of how we can limit or control those powers. The second one has to do with the system we have, the weaknesses inherent in it, particularly party financing, parliamentary independence, and fairness. The third has to do with harnessing our natural resources. How can we as a people benefit more from our natural resources? The fourth one talks about restoring trust in accountability and justice institutions. How do we strengthen the judicial independence and appointment safeguards, reforming the Council of State Charge and such similar institutions? How do we build a professional, merit-based, and capable public service? Very important consideration for that matter. 6, how do we advance social justice, inclusion, and human rights? 7, that is decentralization, how do we make our institutions work? Then the eighth, the politicization of security services, the security leadership. How to avoid that creeping situation. And then nine, how can we ensure that all these proposals are actually implemented? That is the ninth one. And that is where I'll focus more of attention today. For our purposes this morning, let us look at chapter 1. For example, we shall look at chapter 1 as our point of reference. Chapter 1, which is on the presidency, touches on chapter 8 of the Constitution. And chapter 8 is absolutely entrenched. If you look at Article 290, chapter 8 is entrenched in its totality, meaning that any recommendation under chapter 8 would have to come entrenched amendment proceeding. So let's take a look at some of the recommendations under chapter 8. The first one is that we should extend the length of a president's term from 4 years to 5 years. As I said, I'm not here to tell you my own views. But for this one, if you ask me, I'll say no. Because if you are stuck with a bad president for 10 years, because let's face it, it's very hard for an incumbent to lose. It's often hard. So if you have a bad president from the first term, you are stuck with him for 10 years. That's too much. It's too long. Equally, though, if you have a good president, that's fine. But please, let's have the default, the bad president. So, but that is what we have. That's what we've been given. I believe those who have served as presidents before must have told them something. And based on that, this is what we have. But me looking at it, we should have maintained the 4 years. If you have a good president, let him or her perform well and prepare the ground and nurture others to follow. But if you have a bad one, 10 years. Anyway, that's not before us here. But as I said, that's an entrenched provision. Then we have also the minimum age, which is to be brought down from 40 to 30, also entrenched. And then you have that we amend Article 57(6) to make possible the prosecution of, the bringing of private civil proceedings against a president immediately when she leaves office. That's fine. And then we have that if you are a member of parliament, you cannot be appointed a minister. The hybrid system we have, I think is good. Then you have the total number of ministers. We are trying to cap them not to be more than the number of a certain percentage of the cabinet. That's good also. And then under the current constitution, if Parliament passes a vote of censure in a minister, the president may or may not sack him or her. But now we want him to be sacked. Whether the president likes it or not, he or she must act on it. Now, these are some of the proposals. And as I said, they are all entrenched as at now. To amend them, you must go through a referendum. That's difficult. But so let's use that as our discussion point. So, and a large number of proposals in this report also come under entrenched provisions. So how can that be avoided? Earlier on, in another paper we did for IDEC, Professor Atupare, now the Dean of the School of Law, and I have argued that it would be unconstitutional under the current constitution to put together a number of entrenched provisions into one referendum question. You cannot ask me whether I agree that the term of the president should be extended to 5 years. That's a question on its own. And then another one is whether the ministers should be members of parliament, could be members of parliament or not. You can ask me those two questions or more such questions, and then give me one question, yes or no. I may not want the president's term to be extended, as I've just indicated, but I may want the constitution to be amended, making it impossible for a member of parliament to be a minister. So if you give me one question, yes or no, which one do I take? So we had argued that it would be very unconstitutional to put together all the provisions, particularly the entrenched provisions, into one, under one question, and ask us to answer yes or no. And indeed, the CRC2 acknowledged that. So the question now is, with all these provisions, many of them coming under entrenched, how do we address the position? That was the position, that was a problem which we had with respect to the Atamils or CRC1. We had stated that no, you cannot put all these provisions in one question. So how do you approach it? It didn't come up because the process was truncated. Now it appears the CRC2 has thought it through. And what I presume, or the reason for their focusing so much on Article 290, on the entrenched provisions, how to amend the entrenched positions, is that hopefully, once you amend Article 290, removing much of the entrenched provisions from thereunder and making them non-entrenched, whether you call it semi-entrenched or non-entrenched, the same thing. Once you remove them from being entrenched, you make it possible for Parliament to amend. As for the amendment by Parliament, it's possible. Parliament can line up all the provisions that are within its capacity. You can line all of them under one bill, discuss them one after the other in the same process, and then pass as one process. So I'm sure that is the intention. So what did they propose? They proposed that the Article 290, which lists the entrenched provisions, be amended so that we now separate what we regard as those provisions that are so fundamental to our constitutional system. We separate them from those that are not so fundamental. They are fundamental, but not so fundamental. Not going to the core of our very existence as a nation. For instance, Ghana shall be a republic. That not negotiate. The supremacy of the Constitution itself, that we cannot negotiate. Those kind of provisions must be retained as entrenched. And others that may not be too fundamental, we can do with that. For instance, happily, they didn't, in fact, they spoke about it, but left it as it is. That the president shall have only 2 terms. It's so fundamental that they have left it. But the 4 years to 5 years, that one, they think, oh, we can change it. But are we sure it's not so fundamental? If I should become president, and I'm so interested in staying for the next 90 years, like our friend in Cameroon, I can get people, I can get members of parliament to amend the now semi-entrenched provision. I think it's possible. I can get parliament to amend the now semi-entrenched provision, extending my term to as long as I like. Anyway, that is, as I said, we don't get into those. We don't have too much time to get into those. But now we have a proposed category to be called semi-entrenched, in addition to the already existing non-entrenched. Now, for the semi-entrenched, the proposal is that we have a super majority of parliament approving its amendment, whilst for the, that's 75%, whilst for the non-entrenched, it's 2/3 of all members of parliament. Right now we have 276 members. It just means that for the non-entrenched we need 108 or 186 or so of members of parliament to approve it. For the now semi-entrenched, 75%, we need 204 to approve it. That is the proposal. With that, as I said, once we succeed in amending the current Article 290, we have paved the way for Parliament to amend all the other provisions, excluding the entrenched, the super entrenched. Now, let's quickly move on and look at a timeline, taking into account the fact that President Mahama has under 3 years to go. And also let's take into account the fact that amendments in Ghana would depend on the discretion of the president. So if he doesn't do it now, if he doesn't get it done under his present administration, you cannot be sure that the next president will be too interested in carrying on, as we saw with CRC1 and others. So let's look at how we can succeed with what we have now under President Mahama. Let me confess, I don't know what stage the process is now. I haven't heard anything. But let's assume that by September, government would have come out with what exactly the intention is about this report, and that by that September, we have a bill for the amendment of Article 290. So I'm giving September because that should be about 5-6 months. April, May, June, July, August, September. Yeah. So now let's assume that by September we have a bill. Now let's go through the process. That bill is ready before Cabinet, or has been approved by Cabinet in September 2026. Now the bill goes to the Speaker. Let's say in October, the Speaker receives the bill and sends it to the Council of State, as he's supposed to do. Council of State has 30 days within which to give his advice thereon. So let's say we take the whole of October for Council of State to work on it. Then the bill returns to the Speaker in November. Let's say 1st November, the bill goes back to the Speaker. And the Speaker the Speaker gets it gazetted. It must be gazetted for 6 months. 6 months before it can be in for the first reading. So let's assume that 6 months will be from, let's say January, the gazetting starts January 1st, 2027. Because if the Speaker receives it in November, I'm sure by the time other things are done, administrative processes are gone through, we are already in December. So let's assume that the bill is gazetted. 1st January will be a holiday. So let's say it's gazetted 31st December for 6 months. That will take us to the end of June. 6 months. June 2027. And then June 2027, let's say in July, the first reading is done in Parliament. After the first reading, there must be a referendum. And let's assume we move very fast, that first reading in July 2027, the referendum in August 2027. And then the President assents to the bill. So that's assuming we start from September this year, September next year, 2027, the President would have signed. Meaning the way is now open for Parliament to amend the other provisions, going through the parliamentary process. Now let's look at the parliamentary process. First, there must be publication in the Gazette. That is looking at Article 291, Clause 1. First, there must be publication in the Gazette. That's assuming after the President had assented, we move again very fast. And we are able to get all the semi-entrenched and non-entrenched formulated into a very long, voluminous document for Parliament to consider as one. So it must first be published in the Gazette, followed by a second publication. That should be at least 3 months at least 3 months after the first publication. Then, at least 10 days after that 3 months, the Speaker refers the bill to the Council of State for advice. And the Council of State will take 30 days to look at it. After that, Parliament now will have to approve the bills, depending, each of them must be approved separately, depending on if it is a semi-entrenched it must be approved 75% of all the members of Parliament. If it is non-entrenched, then 2/3 of all the members of Parliament. Now, I am modestly estimating that, taking a look at the volume of material that will be before them and the debate that will go on, I'm giving them 6 months. 6 months to do that. I'm not sure if you agree with me. 6 months for them to debate whether the president should have 5 years or 4 years, whether a minister can be member of parliament or not member of parliament, all of them, within 6 months. And then, if that is done, through the 2 readings, second and third reading, then and passed, then the president signs. I give about 11 months, if I complete it, I give about 11 months for this process. So if they start somewhere after September 2027, I'm sure it will not start immediately that September. September 2027, that was when the president assented to the referendum, the result of the referendum. It will start in September. So let's say we start in December. 7 months from December will take us to where? 2028 October, or thereabout. July. Is it July? Okay. That is assuming we are so time conscious. We speed up things. But I don't sincerely think we can rush through all this process to achieve that result by July or August. Bearing in mind, 2028, members of Parliament will be so busy with more important things. Of course, that's election for them. They are not going to be sitting in Parliament considering those bills as they should do. So, my pessimistic view is that possibly we may succeed with the amendment of Article 290. But for Parliament to look at the various provisions, other provisions, and amend before the end of His Excellency's term, I have my doubts. That means it will take us into the next government's session. Perhaps, if NDC wins again, it may be a bit smoother. If they don't, you can be sure it will be tough. So, this takes us to the question of how do we ensure that this doesn't get stalled again? How do we ensure that it's carried, irrespective of who is in power or which party is in power, it continues? So in that respect, we have a recommendation from the committee, the CRC2, that we have specialized institutions put in place that will, on a continuous basis, monitor the implementation of the amendment process. That's fine. Indeed. They think that we should not make it a constitutional provision. We should not embed that recommendation in the Constitution, but rather by perhaps ordinary legislation. That could be done. But I would have preferred a situation where we have a regular review process embedded in the Constitution, because it looks like Ghanaians, we have come to like amendments. Let us embed it in the Constitution, like we have in the Constitution of California, the state constitutions of California and Illinois. There, after a period of, I think, 20 to 25 years, it becomes an automatic process whereby the legislative bodies are converted into constituent assemblies. Over the period, they would have received proposals for amendment. So when the time comes, that body, the legislature, is converted into a legislative assembly. And they go through the process of the making of a constitution. They would have received memos from the public, have consultations, and then eventually may, as a body, approve it, and then that constitution, that proposed constitution, now goes to the people in a referendum at the next election, so that when they are going to have election for that year, the new constitution is added for approval, yes or no. So that gives you the opportunity, or gives the people the opportunity to have a comprehensive review of the Constitution. But the way we have this one put here by the CRC2, it would mean that we'll still have to be doing it piecemeal. We have a body that will be collating the proposals for amendment, and then perhaps from time to time they will put it before Parliament to consider, and that perhaps may not be neat. If our Constitution had provided for the kind of situation we have in the Illinois and California situation, we wouldn't be stuck with this. We would just have looked at all the proposals we have before us, and then in one referendum, the question will be, do you approve the new proposal as the new constitution? We say yes, and then that's it. So, but this is what we have now, as I keep on saying. How can we ensure that we get all these proposals amended? So if I must conclude, first is that, which perhaps may not be possible, we get His Excellency, the President, to speed up everything so that we get the amendment of Article 290 done through referendum, and then Parliament is also pushed to ensure that we get all the other provisions amended through the regular processes. Otherwise, we just hope that we may succeed now with the amending the 290, and then hope that the next administration will be interested in pushing the others through. Thank you very much.
Thank you very much, Professor Kofi Kwashiga. I think that you'll all agree with me that his presentation has been probing, very insightful, perceptive, and must keep us on our toes thinking as to how we can prefer solutions or outcomes that would stem the tide of stalled implementation processes for our constitutional reforms. Thank you so much, Professor Kwashiga. One of the things I picked from Professor Kwashiga's presentation was the fact that he is advocating for a regular form of reviewing our constitution, perhaps a body or a commission. And I think that the Institute for Democratic Governance has worked over the years to propose the Multi-Party Democracy and Constitutional Reform Commission, which would handle some of these on a regular basis, a permanent body. And to my understanding, the Prempeh Constitution Review Committee has proposed something similar, basically, because we made inputs during the consultative processes. And on that note, I think that I would like to perhaps invite one of our own to look at the institutional safeguards, in addressing some of these issues. Why do reforms lose momentum across political transitions? Do we need a permanent constitutional reform body, for instance, as I mentioned just a short while ago? How can Parliament play a stronger role in implementation? And what mechanisms should be put in place to ensure continuity and accountability across governments? Is the failure to implement constitution reform recommendations an institutional problem or a political will problem? I do know that some of you would have questions to answer. We'll come to the question and answer segment. I'd like to invite Prof. Jonah, but before he comes to the podium, let me inform you that my executive director is in the house. He's in the person of Dr. Emmanuel O. Akwete. And we're also joined by our online participants. And when we get to the question and answer segment, we would invite some comments or questions from them. We do have a gender advocate amongst us. I'll come to her in the course of the program. But to help us move further from Professor Kwashiga's presentation, may I invite Prof. Jonah to the mic.
Thank you so very much, Patrick, for your very generous introduction. And my boss, even though you came late, I want to salute you. Distinguished ladies and gentlemen, after listening very carefully to Professor Kofi Kwashiga's presentation, especially the pessimism he expressed about the possibility of the Constitutional Review Committee's recommendations all being implemented under the term of the current president, I would like to give him my definition of a pessimist. A pessimist is the most realistic optimist. So, Prof, your pessimism is not bad. A pessimist is the most realistic optimist. Is one who looks at everything very, very carefully. So your pessimism about the process, I share a similar pessimism about the possibility of completing the entire process within the next 2.5 or so years left. But let's see what will happen. Now, distinguished ladies and gentlemen, my simple duty this morning is to address the question of what institutional arrangements can we make as a nation to stem the tide of endless cycles of incomplete constitutional reform processes? Anybody who paid attention both to Patrick, to Professor Kwesiga, we have made so many efforts in the past to get a constitutional reform process over the line. We started January 2010. 1.5 decades later, we are still in the process of amending the Constitution. So what has been the problem? From the IDEC perspective, after very carefully looking at the endless cycle of incomplete constitutional reform processes, we came to the conclusion that perhaps if we had a constitutional body, a permanent constitutional body that would take charge of the process of constitutional reform, the process would be much more efficient and effective. The endless cycles of reform efforts will come to an end. And this is precisely what I am going to address today. IDEC's proposal for ensuring that there is a constitutional body that will take charge of the process of constitutional reform so that we do not end the same old place where one president comes, he starts a movement, it's not completed, another president comes and starts another process. Patrick, and to a certain extent Professor Kwesiga, gave us so many instances. January 2010, the late Professor Tamil set up the Constitutional Review Commission. Then they submitted the report November 2011, and then a Constitutional Review Implementation Committee was set up, which came up with 97 proposals for amending the Constitution. Nothing happened. Then President Akufo-Addo comes. He also makes an effort. He said, I am not interested in wholesale amendment of the Constitution. So he tried to do two key amendments. Amendment number 1, allow the people, amend the Constitution to allow the people to elect their own chief executives. Because it is not right for a president to sit in Accra and appoint district chief executives for the people. So he said, I am going to amend this one. The second amendment he was interested in. Why is it that political parties can actively participate in national decision making, but are not allowed to participate in decision making at a district level? So he was also going to amend the Constitution to legalize the participation of political parties at the district assembly level. Unfortunately, by the end of 2019, he had failed. He had failed. The referendum that he wanted to amend, used to amend the entrenched Article 55(3) to bring in political parties, and then everything failed. Then, when that one failed, his Minister of Parliamentary Affairs, Honorable Osei Che Mensah Bonsu, who was at the same time the majority leader and the member of parliament for Swami constituency, said, the process should not stop here. I want to initiate another attempt. So he set up a Constitutional Review Consultative Committee. They came up with 14 recommendations. Same story. They presented their report after the MPP had been comprehensively defeated in the 2024 election. So Professor Akufo-Addo said, I can only take this report, but I cannot act on it. I will refer it to the next president, which is why this new president started the constitutional review process very, very early. Because by the time they submitted the report to him, he was on his way out. He had just about 2 weeks to leave the Flagstaff House. So on and on and on. Now, why, according to ADEG, why is this happening? Because we don't have a permanent body. So ADEG suggested that when we said this to the Constitutional Review Committee, let us create a multi-party democracy and Constitutional Review Commission MDCRC, Multi-Party Democracy and Constitutional Review Commission. Make it a constitutional body, a permanent body that will take charge of the process of constitutional reform so that it does not become political. So, why did we make this proposal? I would like us to take a look at the context. Two elements of the context are very important. What will this multi-party democracy and constitutional review commission do? Two contexts very important. Context number one, we realized that, one, the Ghana Electoral Commission, as constituted under the present constitution, has two broad functions. One set of functions relate directly to the conduct of elections, demarcating constituency boundaries, registering voters, managing the voters' register, and conducting elections. When it comes to this part of their function, the EC is very active. Voter registration, very quickly they'll do it. Elections, they'll do it. But the other function of the EC, regulatory, regulating the political parties, the EC is not able, I wouldn't say they don't do it at all, they are not able to do it as effectively. Why? Because they have never been able to find the right balance between the election-related functions and the regulatory function. So we said, if this is the case, the time has come for us to hive off, to take off some of the non-election related functions of the EC and give it to a completely different body. That is one reason why the idea of a multi-party democracy and constitutional review commission came up. So you hive off those functions of the EC that are not being actively performed now and give it to a new body, the Multi-Party Democracy and Constitutional Review Commission. The second context has to do with the process of constitutional review. Now, what has happened is, if you take a critical look at the process, there are two broad approaches to constitutional reform in this country. We have the broad and the comprehensive approach, and the narrow, focused, targeted approach. The narrow, focused, targeted approach is that approach which says that, look, we have a 1992 constitution that has served the nation very, very well. For 33 years, stability. There's no need to tamper with it completely. Just make a few selected strategic amendments that will enable the system to continue functioning. Just 1, 2, 3 amendments. That is the narrow approach. And then we have the comprehensive approach, which says that there's too many things wrong with the Constitution. Amend the whole thing. The Constitutional Review Commission, which was set up January 2020, submitted its report in November 2010, and then submitted its report 2011, is such an approach. 97 different recommendations for amendment. And the present Constitutional Review Committee is also the comprehensive. They have recommended over 100 changes to the Constitution. So, we have these two broad approaches. Unfortunately, it doesn't really matter whether it is a narrow focused approach or the comprehensive approach. We are never able to get over the line. So IDEC is saying that set up a multi-party democracy and constitutional review commission that to take charge of the two problems that I've identified. The EC's inability to perform certain functions and the nation's inability to complete constitutional reform processes. So you will see that the multi-party democracy and constitutional review commission will have two broad functions. The first set of functions will deal with building the capacity of the political parties, regulating them, so that we have will be implemented whether government changes or not. Because the permanent commission in charge of the constitutional review, whatever recommendations they have, they will go over and make sure. Now, we know for a fact that new constitutions are reviewed 19, 20 years' time. Every 19, 20 years, people want to take a look again at their constitution and see whether some changes are needed. And that is why the late President, Professor John Fifi Atta Mills, in 2010, initiated the Constitutional Review Commission. Because in 2012, the present constitution was going to be 20 years. And it was his hope and expectation that by the time the constitution attained age 20, some amendments would have been done. Unfortunately. So the IDEC proposal for multi-party democracy and constitutional review commission is intended to be a constitutional, non-partisan technical body that will ensure that constitutional reforms are implemented regardless of who is in power. One of the main problems is the two parties are never able to reach a consensus. If the proposals of the Constitutional Review Commission were never implemented, lack of consensus between the NDC and the NPP was a very big part of the story. And believe you me, the reason why I secretly associate myself with the pessimism of the professor is that the moment we allow the political campaign for the 2028 elections to kick in, it is going to be extremely difficult to get the two sides to agree. I mean, amending a constitution to govern the entire country is something that should be done by consensus. You don't use your majority to pull your way through. You want to make sure that the amendments you have made enjoy the support of the entire nation, regardless of where you find yourself on the political spectrum. But if we delay and we get into the middle of the campaign, this kind of consensus is going to be extremely, very, very difficult to attain. So, distinguished ladies and gentlemen, the Multi-Party Democracy and Constitutional Review Commission is IDEC's proposal for resolving this problem of endless cycles of incomplete constitutional processes. Made the full detailed proposals to the CRC. What they brought into the, partly accepted, is the regulator, the registrar of political parties, registrar of and regulator of political parties and election candidates. They didn't accept the full, but this was the intention behind it, to create a body. So I think that it is not too late to go back to the idea, because we have all the documents presented to the Constitutional Review Commission. Now, let me tell you why I believe that it is not too late to go back to the idea. The constitutional amendment or reform process, bottom line, it will end up in Parliament. You cannot amend the Constitution without Parliament. And if and when the proposals are put before Parliament, every citizen, every group, including IDEC, will be free to appeal to Parliament, to make recommendations to Parliament. So it doesn't matter whether the idea of the Multi-Party Democracy and Constitutional Review Commission has been included in the recommendations of the CRC or not. The good news is that it is not too late for IDEC and other like-minded people to pursue the idea of establishing a permanent constitutional body that will make sure that constitutional reform does not become impeded because of political differences, because of any other problem. Distinguished ladies and gentlemen, if you have any concerns, you shall take it up during question time. I thank you.
Thank you very much, Prof. Jonah. And so we have food for thought. He's told us so much, and I believe that you'll be pondering. You all have questions to ask, but please hold your horses. We do have a gender advocate in our midst. But before then, I'd like to say that there are quite a number of participants here, and it would be a pleasure to acknowledge them. I forgot to inform you that Prof. Jonah is a senior research fellow in charge of advocacy and institutional relations. A round of applause for him, please. And so we're joined by organizations present. We do have Oxfam in our midst. Please, when your name is mentioned, the name of your organization, please just give us a wave. Oxfam, CFI, the Czech Embassy, National Counterterrorism Fusion Center, Youth Bridge Foundation, OTTCS, ICAJ, of course, AA Law Coalition is with us. NDPC, NALAG is here. Prisons Service, CSA, Genset, Merton and Everett, NCCE, Political Party Reps, NPP. We have a representative from the NPP here. Thank you for coming. Abantu, right. The Affirmative Action Act Coalition, right. UNIMAC is here. NORSAC in our midst. Transparency International Ghana, CDD Ghana, GACC, CEPIL, Gimpa Law School, right? NCPD, accountable for persons with disability. PN Africa. NetRight is here. We do have USA Law School faculty. Media Foundation for West Africa. I can see Abigail Labi. University of Ghana Law Student Union, right, and Ghana Education Service. We are so happy you are able to join us for this policy dialogue. Thank you so much for coming. And of course, we have our media persons also covering this program. I see GNA, I see TV3, and I think I'll be acknowledging the rest of you in the course of the program. Thank you. And so at this juncture, we'll move on to invite our gender advocate to also share some thoughts with us. What I'd like to ask is, why has women's representation remained low despite reform efforts? How essential is a constitutional quota? What quota model do you think will work best in Ghana? And in a nutshell, what we're seeking to find is, how do we ensure gender reforms are treated as core and not optional? And to take us is a lady amongst the panelists, and with your kind permission, I'd like to read her profile. Just a few minutes. And quite a number of papers with me. And so let me grab this. Right. Here we go. Distinguished guests, ladies and gentlemen, Becky Enyonam Ahazi is a passionate lawyer and advocate for gender and child rights, currently serving as the coordinator of the Affirmative Action Law Coalition, which played a pivotal role in the landmark passage of Ghana's 2024 Affirmative Action Gender Equity Act. Becky has extensive experience developing legal documentation and the review of critical policies and acts, including the Affirmative Action Gender Equity Act, Non-Profit Organizations Bill, the Domestic Violence Act and National Plan of Action, as well as the National Gender Policy. Additionally, she has hands-on experience working with women's rights organizations, gaining insights into the challenges faced by women, which she seeks to address through policy and legislation. As a development consultant with an LLM in gender and the law from the University of Ghana, she provides gender-sensitive training and consultations to institutions, civil society, and women's rights organizations to strengthen the institutional framework and advocacy, respectively. Becky also serves as an lawyer with ALC Law Consult, managing corporate legal matters in the extractive sector. Her dedication to gender equality and corporate law reinforces her role as an advocate for women's rights in Ghana. I have the honor and privilege to welcome Becky Ahaji Esquire.
Thanks, Patrick. Good morning, everyone. So this morning, my assignment is very simple, but then also I think it's very critical. Sometimes when we are discussing national issues, it seems gender is sort of an afterthought. But I'd like to thank IDEC for the opportunity that we are having this important conversation, and you ensure that we are not an afterthought, but then we have a say in the whole process. So thank you very much. I'm here on behalf of the Affirmative Action Law Coalition, and it's just a group of CSOs and individuals that were working towards the passage, and now we are focused on implementation of the law. One will be wondering, what's our interest in this whole constitutional review process or the implementation or whatever is coming out of it? It's because even during the stakeholder consultations by the current committee, that's Professor or Dr. Prempeh? Is he a professor? He's professor, thank you. Professor Prempeh's, the CLC, we made a proposal from the coalition, and our key proposal was for constitutional quotas for gender in our current constitution. And that was because in the process of getting the act through in Parliament, the most significant challenge we faced was that we wanted to, reserve safe seats for women and all of that. And I remember our very first meeting with the parliamentarians who were told point blank, there's nothing in your constitution that has gender considerations for who can go to Parliament or who can go to local government. And if you guys continue to push for the bill as it is, we'll challenge it in courts, and your act will be unconstitutional. So right from there, that's what informed our decision that even though we have the act as it is, if there's any constitutional process or reform process where we can get in gender-specific quotas and considerations, we'll push for that just to strengthen the law. So just to give a background of why we are having the gender conversation here, so it doesn't feel like an afterthought. I hope I've been able to tease it together. Now, let me move on to Patrick's questions. First, I'd like to pick it back off what Prof said. By the way, Prof, thank you very much. I don't think Prof remembers me, but he taught me constitutional law. So when I saw the panel, I was a little bit intimidated to be speaking with your professor. But Prof, nice to see you. And Prof made a very important statement. He said that the reason why we keep coming back to reforms for our constitution is because of dissatisfaction with our governance. And that's where the conversation starts. And even as women, or should I say women in Ghana to be specific, the reason why over the years we are pushing for quotas, we are pushing for affirmative action, is that the dissatisfaction we have with the way governance has been, should I say, captured by a certain sex over the years, through no fault of yours, by the way. I know I'm outnumbered in this room. But the conversation is that there is a systemic and systematic exclusion of women when it comes to governance. And all the attempts we've seen over the years, whether they're legal reforms or constitutional reforms, they're all targeted at the appointed positions. And then we leave out the elected positions. And that's where the challenge is. Because where power is actually contested is where the women are being excluded. So just to answer Patrick's first question about why do we even have low representation in the first place? Because someone might argue that in the Constitution, there's nothing barring women from standing for elections or nothing barring us from being appointed. That is all well and true. Article 17 clearly says that there is no discrimination on the basis of gender. So that is all well and true. But we all know that there's de facto and then there's de jure. In fact, what is actually happening on the ground, even though on the face of it says don't exclude women. We live in a country where currently you have 276 members of parliament, only 41 are women. That's about 14.5%. The only time we've ever even reached 18% happened in 1960 when the first president of the country, that's Dr. Kwame Nkrumah, he passed what we call the People's Representations Act. And in that act, he decided that, look, the women contributed to us gaining independence. And so I'm going to ensure that for every region, that then we had 10 regions of Ghana, we're going to have one woman coming as a special seat. And so that happened in 1960. We had 10 women forming 9.6%. Then you see that in the year 1965, when we had our first elections, the number of women increased from that 9.5% all the way to 18%. And then in 1966, we had the coup d'etat, and then everything plateaued from there. So that should tell you that affirmative action has worked in Ghana before. We brought the women in, people saw the women working, and then the next elections, the numbers went up. But then that also shows us a challenge that if you leave if you leave the system to the caprices of whoever is in power at the time, it will not be sustained. We need a sort of a permanent mode. You can't have a system where, because Kwame Nkrumah was there at the time, he was able to come up with a measure. The moment he left, everything plateaued. And that's why we are so focused on having it in our constitution, where it's not left to the whims and caprices of whichever government or person is in power at the time. Now, the reason why representation has remained low and might continue to remain low, for me personally, I'll speak to 4 points why I think it's low and why we might need the quotas to fix that. The first thing is our electoral system. We practice a first-past-the-post electoral system where the winner takes all, and that has been very challenging. And if you look at other countries where women's representation has increased, it's because they practice proportional representation. So you look at Rwanda, you look at Kenya, and they have constitutional quotas. So based on those quotas, the electoral system had to be one of a proportional representation, because it was not just quotas for women. For Kenya like this, we are talking about youth, persons with disability. Everybody sort of had a quota. And so because of that, looking towards a more inclusive democracy, they decided this electoral system. Now for us in Ghana, because it's first past the post and it's a winner takes all thing, and looking at the terrain of how patriarchal our society is, and how even if you come up with, everybody keeps saying, oh, you just have to train the women more to be harder. And my point is, you live in a culture where they don't even want to recognize women as leaders. And even the few ones that decide to come up, they come up and they are faced with violence, they are faced with abuse, they are faced with rhetorics and gender-specific attacks. So the whole environment is actually not even conducive in the first place. Then the second thing is the monetization of our politics, which I'm glad something that the CRC2 touched on. But then it affects women more disproportionately because we are the ones who don't even have access to resources in the first place, as much as the men. And if the campaign, some political parties argue that, yes, you've halved filing fees for women, but we all know that the real cost of the election isn't the campaign, true or false. It's not the filing fees. And so you might come up with measures like this, but then in the end, you're not dealing with the real structural issue which the women are facing. And then also, another thing is the reliance on political parties to be the one to come up with the measures to ensure we have a more inclusive democracy. Over the years, we've all relied on political parties coming up with their own internal measures and all of that. But if there's no accountability system where it is like an imperative from the supreme law of the land that says that you have to do this, you have to ensure this representation, they are not bound to do so. And that is why we need gender-specific quotas in our constitution. Now, to move on to the argument now, or should I, not the arguments, I'm not in court. Thank you, I'm not in court. The problem now is the CRC report came out, and even though we made these recommendations, another challenge came up. The only thing, number one, just to be honest, they didn't take our proposal for gender-specific quota. So I read the recommendations that came back. That was not in it. But I noticed the pattern. The only thing that touched mainly for gender was the fact that with Article 17, it should be very specific that affirmative action at least make sure that you don't have more than two-thirds of a gender being in an appointive position. And therein lies the problem again. It's like we are choosing the easy way out. Let's just deal with, if it comes to appointments, let's give them a quotas. And then with the elected positions where the real problem is still being left unattended to. And that is the challenge. In the CRC2 report, they did recommend that Ghana can consider proportional representation and that there should be a whole study on which method is available and all of that. But then I think that the gender-specific quotas would have been a start, right? If even that was accepted and considered, that could be a linchpin or that could be a bargaining tool to ensure that we can now have proportional representation or maybe reforms to our electoral system however we want it. And it is very sad because women form more than 50% of this population, of the population of Ghana. And it is even much more sad that whenever we are even going to the polls, the total number of registered voters, more than half are women. So we do have a bit of bargaining power, but it seems we are always left in the background and the conversation is just among a few elite. And my question actually today, when I was preparing for this, I just had a question. I was like, if IDEC or if the committee or with all the measures that are laid out, we are going to the referendum, we're going to the polls, what are you going to give to the women of Ghana as an incentive to say this is a reason why you should come and contribute to this process, especially when most of their recommendations were not taken? And despite that, we are still very committed. We are still partnering with all the institutions or CSOs that are working towards this. But for me this afternoon, or should I say this morning, the conversation for me is, or should I say it's not conversation. Yes. The dialogue for me is that we focus too much on creating a constitutional design to deal with appointed positions, but the real systemic challenges that women face in this country have to do with elected positions. And if we do not come up with a constitutional design, we might end up, and people are so dissatisfied with governance. The reason why you have Rwanda and Kenya having progressive constitutions, they had to go into conflict to come to a place where they rebuilt their political system. We have an opportunity right now with the process that is ongoing. We are trying to rebuild our political system. That is why we are doing these constitutional reforms. And in as much as, yes, we are not coming from a post-conflict place, the honest truth is that if you want to rebuild a political system, and one of the chapters that Prof. rightly said was leaving no one behind, which is a thematic area in Professor Prempeh's committee's report, then let's be intentional about it. The people that are being left behind that have made a lot of noise and advocacy over the years are actually women. And if even in this process where we are rebuilding our political structure, we are still keeping them behind, we are just giving us, should I say, hanging fruits, oh, take appointed positions, that's enough. But when the real problem is with the elected positions, it's with our electoral system, it's with the monetization of our politics and all of that, then we are not doing anyone a favor. It looks like I'm giving more questions than answers, but honestly, that is the reality we have. So just to conclude, what were we advocating for as a coalition? Articles 93 deals with the composition of parliament. Article 242 deals with the composition of local government. Those two are the key places that, looking at the current state of the Affirmative Action Act, we will not be going into the 2028 elections. Honestly, there's not going to be any increase of women's representation if we don't have the constitutional reform to strengthen the act to ensure that political parties comply and to ensure that we actually have a quota in parliament. So we were hoping that, just as Rwanda has it, at least 30% of parliamentarians should be women. For Rwanda and Kenya, they're very specific that for both elective and appointed positions, don't have less than this number. And that's what we were hoping for. But if that's not happened, that's not the case. Why are we still even in this fight? It's because it happened in Lesotho where they came up with just legislation. And that legislation was contested by a man. It's in the case of Molefe and the Independent Electoral Commission. So Lesotho came up with an electoral law, and it was trying to safeguard certain districts for women to contest. And you had a man go to the courts and say that you are discriminating against me because I'm also entitled, to stand for election. There's nothing in our constitution that prevents that. Even though the court didn't find it unconstitutional because they still had a provision which allowed for Parliament to come up with positive discrimination measures, the backlash of that was Lesotho parliamentarians went back and they amended their electoral law, and then the reserved seats they had for women, they altered it. And that's the challenge we are trying to avoid, where even under our current Affirmative Action Act, if political parties decide that, okay, we are going to give strongholds to women, or we are going to do this to, ensure increased women's representation, someone can actually go to court and say it's unconstitutional. Where in our constitution does it say that I cannot contest for this because I'm not of this sex or gender? And that's what we are trying to prevent. And so for me, if we are talking about designing our constitution, talking about timelines, I think that we shouldn't make gender an afterthought, number one. I think that we need to leverage on how can we, even the process just started, we can still make recommendations. How can we ensure that we actually leave no one behind? We don't leave the women behind. Secondly, how can we make sure that even if we have the quota we are advocating for, what reforms can we make to our electoral process to ensure that we come up with electoral processes that are actually very conducive for women, which will increase representation? And then the third thing is that we need to ensure that in as much as we are having this conversation among the politically elite, if I should use that word for us, we don't leave the grassroots behind. Everybody is important in this conversation. The referendum is not going to be done by just the political elite. So how do we come up with measures to make sure that you give people a bargaining power to actually be interested and come to the polls for referendum? So those are my 2 cents. Thank you all very much.
Thank you very much, Becky. I believe that Becky has made a case for women and youth and persons with disability within the gender bracket, and I think she deserves a round of applause for her presentation. We've realized that, and if you didn't know, that we shouldn't be handing out, just any positions to women, appointed positions, but we should safeguard women's rights and ensure that women are thought before and not after in giving them, in supporting them to also attain elected positions. And that is what we should all be focusing on in terms of getting that in our constitutional reform processes. At this juncture, I would like us to move on to the next item on the program, which is contributions, questions, and answers. I believe that you've been putting your thoughts together and you do have some questions to ask. What we'll be doing is, where are my IT guys? Would need an extra microphone, please. My IT manager, Walter. And so you raise your hand, mention your organization, and then we can take your question or contribution. And we'll pick maybe about 4 or 5 questions at a time for our experts. And so the floor is open. Would also welcome questions from our participants online. And that again, I would want our IT team to furnish me with their questions so that I could read them out. Thank you. Any questions? Right. So there's one, there's a lady behind 2, and a gentleman 3. Any more? Another gentleman here, 4 and 5. So let's take the first 5 questions and then we'll move on to the next. And so you raised your hand. I would have done a women's first, but because you raised your hand first, let me give you the opportunity.
Thank you very much. So I have one question for my colleague lawyer, and then I don't know. I have one question for my former lecturer. I'm not too sure he will remember me, but he taught me political science. Okay. So the first question to my colleague lawyer has to do with the gender issue. I teach jurisprudence, and then last week I just happened to teach feminism. But one question that I've been asking myself, how does the argument for female representation resonate with females? Because I've come to the conclusion that, well, they can decide whatever they want to decide when it comes to elections. They can decide today that the next president will be a female, and it will be a female. But the same people go and then they will vote for men, and then they will come back and complain. So my question, do they believe in themselves? Do they agree that they have to choose their agenda? Or how does it resonate with them? And my second one to my lecturer has to do the body, the new body that they want to set up. In this country, the issue has always been that anytime we have a problem, then we form a body. And we end up multiplying bodies, and the more we multiply the bodies, the more that the problem multiplies, because they end up not doing their works. One of the reasons he gave has to do with the Electoral Commission. I've heard Electoral Commission several times, and they will say that the reason why they could not regulate the political party, not because they don't want to do it, but they say if they want to do it today, not even one political party will survive, including the NDC and then the NPP. So, view to all those things, they decided to just allow them. How does the new body deal with these issues? Because clearly, the issue is not that they are not capable of doing the work. And looking at the cost aspects, if we agree that 20 years, within 20 years, we have to change the constitution, why do we have a body that will wait till 20 years to perform that job? We can have an ad hoc committee, maybe 10 years within a time, or 5 years within a time to do that work. So I would need a bit of clarity on that.
I think this question is targeted at Professor Kwasiga.
Very well.
Okay, so we'll pick the lady who raised her hand. Yes.
Thank you.
Your name, organization.
Okay, Adoma Afokwao, and I'm with the Affirmative Action Act Coalition. So my question is also about the body that Mr. Kwesi Jonas says IDEG is proposing. So I'm asking, in Ghana, we know it's a very partisan state. So how do you ensure, do you have criteria for selecting members of that body in order to ensure that the incumbent does not select its own members to be part of the party? And the second question is also around entry points for accountability.
You have two questions? Okay.
It's just a simple question. I'm just asking if we have entry points to enable CSOs and other Ghanaians to hold people accountable in terms of their constitution and other issues. Thank you.
Thank you.
Could you please stand so we can see you? Yes. So we already have 4 questions.
My name is
we want you to keep it simple.
Gumado from TI Ghana, Transparency International Ghana.
Right.
Mine is a question with some commentary as well.
Okay.
My issue with Professor Kwesi Jonah has been largely been tackled, so I'll not go there again. But the rest will be targeted towards the female issue. In fact, I'm very uncomfortable discussing this issue, but I think the opportunity has come and I have to voice it out. When we talk about quota for women, how are we going to implement this? Because the court, even the constitution, the Supreme Court has ruled several times that the right to be represented is non-negotiable. So you put up a quota, and then maybe safe seat somewhere, maybe Amasaman for MPP, and then no woman is there to represent. Then there are women, but then nobody's interested. Do we then pick anybody because they need to be represented, so that we are now saying that representatives or representing somebody is not based on competence but based on gender? Is it what we are getting to do? And then the next thing is we have to be critical. And the next thing is also we have to think about this thing. Are we trying to reverse engineer society such that you peel off certain rights or certain duties of men to women, and it will get to a point where we'll be having, I would say, feminist society in that men will be constitutionally timid to talk or to act because they are disabled by the constitution. We are in a capitalist state. Everything is based on competition. Let the women compete. Let's encourage them to compete. If we have to encourage them from financial aspect, I will advocate that we set up a fund such that, more like a scholarship fund, such that if a woman is interested in the position and because of lack of funding, he or she is not able to reach there, she taps into the fund and get her fundings correct. But this argument of women are being disabled, I'm afraid we are trying to reverse engineer society, and we will be paying the price in 30 years, 50 years to come.
I'm sure there are quite a number of women here who will raise arms with you. But I think before I come to you, we have a representative from the NPP who would want to leave, and she would want to make some contributions as well. So please let's allow her, and then I'll get back to you. Right.
Thank you very much. So I'm the Deputy General Secretary. I'm representing the General Secretary. Mine is just to say a very big thank you to IDEC for this very, very important dialogue, and to emphatically say that when the invitation came and was sent to my desk, the first thing I told my General Secretary, Kodia, was, but this is for the legal department. Why are you asking me to come? It has nothing to do with me. And I want to make the comment that I think that is what a lot of us in Ghana are doing. If it's constitutional, if it's legal, it has nothing to do with me. But this has been so educative and informative I'm shocked at how attentive I was, because I entered with my laptop hoping to do other things, but I didn't do it. I just listened with rapt attention. And I'd encourage you to take this to a wider platform, because I think a lot of us are ignorant about what the constitutional review process means. It is not political. It is about Ghana. And I think we should go out and spread the word. And I thank the presenters. You were very clear in your terms. I was looking out for constitutional and legal jargons and to say this was very technical. We didn't understand what you said. But you put everything to our level. And I want to commend you and to encourage IDEC and Dr. Akwete. Please do more of this. It's important that we all get educated. So I wanted to say this before I leave. Thank you.
Thank you very much. Thank you so much. Before our experts respond to some of the questions that have been asked, the board chair of TI is here, and he would want to make some clarifications to the comment that was made shortly before she made her remarks. So I would welcome Reverend Dr. Emmanuel Ansah. Yes.
Thank you very much. I think our brother spoke in his personal capacity. So please don't misconstrue things. He spoke in his personal capacity. It's an opinion he personally holds. Our executive director is a woman and a lady, and the immediate past chair, the one who I took over from, is a woman. And we've had several. We respect the rights of women and all of that. We've done well to, even the board, the composition of the board, let me say that we are 9 members, that we have about 5 or 6 women now. We've been progressively encouraging the appointment of women on the board. So it's an intentional thing that we feel that for a long time, women have not had their voice being heard in their organization. So in fact, it's globally, it's part of the TI policy to encourage that women and others who have the numbers but have been treated as the minority are heard. So much as the ED couldn't come and send a rep, take it as a personal comment. I want to also add that we should be very positive about these things. I know what Professor Kwasiga said, looking at the timelines, it's true that it's going to be very tight, knowing the way politics is done in this country. But advocacy takes a season. The law that she said had been passed, the affirmative action and all of that, some of those laws have been in the pipeline for 12 years, 10 years. So as I speak now, we have a law related to the prisons. I'm also board chair for the Prisons Fellowship, and we're working with the prisons people. And we have something which has been in the parliament for like 12 or 13 years. It's still being worked out about the way to change it from the prison system to a correctional system and to make it more humane and friendly. So it's in this country, there is an institutional problem of law reform. It's very, very difficult. It's a very challenging. So the advocacy has to continue. It's not a one-day thing. So I'm happy that you are encouraging IDEC and CFI and Oxfam and others to go ahead with that. And finally, I want to say that the challenge we have had in this race has been the political will, especially of incumbent governments. Everybody comes with his own agenda. So if you have an idea which is quite different from what the government of the day has, it can be a tug of war. And the representation here shows when the NPP the lady had left, when NPP was in power a few years ago, you would not see any of their representatives in these meetings, very rarely. Now they are in opposition. It's easy for them to release people to come. And it's the same cycle we've been having, and we need to keep engaging until it hits them hard. So let's continue the engagement. It will yield some results someday. Thank you.
Thank you very much, Reverend Dr. Ansah. Do we have a member of the NDC here? There you go. I rest my case. And so I think I'd like our panel of experts to respond to the questions that were asked. The gentleman in front asked 2 questions, and then the lady behind, the fair lady, also asked. A gentleman from TI made his contribution. So who's going to take the first question? Yes, you can go first. Do we have an extra microphone?
Thank you very much. I'm going to start with the first question. So the first question was, how does the argument for... Please, can I sit or have to stand? I can. Okay. How does the argument for female representation resonate with females? And you cited the example of if women really wanted a woman president by now, we'd just go out and vote. So just to backtrack, here's the problem. It's about socialization. We are in a culture, or we're in a system where it is the headship of men. The honest truth is, even if you bring a woman to a group of women, they might... Some of them, because of how they've been socialized to see leadership, to see who qualifies to lead them, they will still choose a man. That's the honest reality. But that is why you have CSOs doing interventions where especially we go to the grassroots and try to, I'm not saying challenge the culture or change the culture, but try to make people understand that leadership is not the preserve of just one gender, that everyone has the equal opportunity to be a leader. And so because you are dealing with the socialization process, it's the same as with the blacks. For a long time, most of them were not able to access higher education. You saw them come up with an affirmative action policy allowing black people to now go to the high-end institutions. And over a while, when they realized that in the US, there was a Supreme Court decision recently, when they realized that, okay, it has balanced out. Now we have a lot of black people now in this institution. Then it stopped. That is the essence of quotas. Quotas are not permanent. It is just you opening up the system, making sure that you've given equal opportunity to people who were previously left out of the system. When the system on its own acclimatizes or balances out, it stops. And I think that's a challenge. And just to tie into the second question about whether we are re-engineering society, this is not about you doing someone a favor. This is not about you. The essence is, let's ask the questions. The fact is, are women excluded from leadership? Yes, they are. The second fact is, are there systems in place that is causing that? Yes, there are. The third thing is, what can you do about it? Because even if you try with the legal interventions and all of them, some of them are not working. Why don't you make it imperative that those who have power have no choice than to put the women there? Now, when society starts to see the women in there and they start working, you will see that society will progressively move towards it. That's why you have in Namibia, they saw their women working. Now they have a woman president, they have a woman prime minister. That is how society works. It will take a while, but it takes you being intentional about, I'm opening up the space and giving this person the position for a period of time. Affirmative action is not continual. It is just a stepping stone. You do that over a period of time, society acclimatizes, and then it moves from there. We have the same thing. We did affirmative action. In the beginning, you didn't have girls going to school. We started the Send Your Girl Child to School campaign. Now you have a lot more girls in school. So that's how it works. But if you're not intentional about opening up the space in the beginning, you will never have what you want. Shall I say, never have what you want. What is actually right? We are talking about justice, not even about what women want, but it's justice. If you are having laws being passed, recently I was so sad because I saw the Committee for Constitutional and Legal Affairs in Parliament, not a single woman. And are we saying that laws and bills will not go before that committee that affect women, but there was not a single woman? And that's what we are talking about, because on the face of it, there are laws that could be passed and they have impacts, or they could have very, what word should I use? They could have very diverse impacts on one gender as opposed to the other. But if you don't have a seat at the table, you can't advocate for yourself. And when we are talking about quotas, sometimes we think there are some group of women sitting somewhere that want to capture power, but we're talking about your sister, you're talking about your wife, you're talking about your mother, you're talking about people that you have invested in, you are encouraging them to go to school, you are investing in them as a country and STEM education and all of that. Now we've come to a point in this country where we need all the resources we've invested in our people to come to bear when we are taking decisions. And we are saying that, look, we've invested in women over the years, from all this send your girl child to school campaign and STEM and all of them. Let them come to the decision-making table and bring their perspectives. When you look at the Scandinavian countries, they are doing so well because they are so intentional with gender inclusion. And I remember during the COVID time, I read this article by Forbes. And sorry, I'm going on and on because he actually triggered me, so sorry. There was this article by Forbes where they compared the then Norwegian, what's the name? Sorry, Norwegian Prime Minister. Wasn't Norwegian? Thank you. That's the word. Norwegian Prime Minister, and then they compared the UK. No, so it was German. No, it was Germany, and then UK, and then Australia and Norway, if I remember. Yes, I think at the time was a woman, and they were talking about how each of them handled the COVID pandemic, and the report showed how because these women, because they were coming from a protective standpoint, the way they handled the crisis and the way it didn't have a devastating impact on their country, as opposed to the other countries which are also of the same economy but were managed by men, showed that sometimes just your perspective on issues and just how you have been able to handle issues over the course of a period of time works. And so we need to move beyond the argument of whether women actually resonate with having other women in leadership and come to the point of, is this justice? Where you have invested in people, but you're not allowing them to contribute their quota. We've done this for years. We've had a lot of men leadership for years. No one has had a problem. The moment women say we also want to start the table, you are beginning to have a problem. And I think that's very challenging. So for me, don't look at it as some group of women sitting somewhere. We are investing in women already. Now we are saying that bring that capacity and their knowledge to bear so that our country can move forward. My boss, Shilamika Premo, always says that it's like you are walking with two legs, you've tied one leg behind. How do you expect to walk fast? Release the other leg so that we can run forward as a country. Thank you very much.
Yeah, okay, so thank you so much, Becky, for the very good answer you gave. One question that came to me is to the effect that if we create this multi-party democracy and constitutional review commission, wouldn't we simply be multiplying constitutional bodies and so on and so forth? And then the other aspect relates to how do you constitute such a body, given the fact that the country is so politically divided, whoever you put there may belong to this or that party and so on and so forth. Well, I very much sympathize with the idea of multiplication of constitutional bodies and so on and so forth. But if you take a very careful look at how many attempts we have made between 2010 and now, I think everybody would agree that the time to establish a permanent body that will avoid coming back to the problem every few years would be good for the entire nation. Since 2010, January 2010, look at the attempts. And if you listen to Prof very well, if you're not very careful, this present one is going to end up the same way as the previous ones. So the time has come for us to set up a professional, non-partisan, independent body that would take charge of the problem. Now, the difficulty of appointing people, because people will have different... in the same country, we have SHRAJ, Constitutional... Okay, you have SHRAJ, what's the full name? We have National Media Commission. There are different ways of doing it. The constitution that provides for that can, for example, say that this body should bring a representative, that body should bring a representative, that the National Media Commission, this is how it is constituted, so that you avoid this problem of bringing NDC president, bringing in NDC people, MPP president, bringing in NPP people. So there are different ways of avoiding the politicization of such bodies. Then the second question had to do with Yes, okay. The second question deals more with the criteria for selection. I will say that there's no lack of formula for constitutional set bodies. If you go into the Constitution, SHRAJ, National Media Commission, and so on and so forth, they have stipulated very many different ways. So they are constituted in diverse ways to avoid the problem of politicization. So I don't think there'll be any difficulty. You can look at them and see which ones would avoid putting NPP people or only NDC people there. So, and don't also forget, we have put forward the idea. We are not saying that it is cast in stone. If people think this is a good idea, they can also make inputs.
I'd like to pass on the mic to Prof.
Oh, okay. Well, Prof has answered it, but if I may take from what Prof told us at the very beginning when he started by distinguishing between broad and comprehensive approach to amendment and then the narrow approach. It may be a philosophical question, but if we are going to have a broad or comprehensive amendment of the Constitution, why don't we go back to the same people whose mandate brought out the Constitution in the first place? If we are going in for the narrow amendment, yeah, we pick one or two. Let it go through the normal process of amendment. But if we are going to look at the whole Constitution, it just makes sense that we go back to the people and go through the same process. That is why in some constitutions, as I mentioned earlier on, they have the opportunity at, say, 20 or 25-year periods to subject the whole Constitution to a comprehensive review. And some will convert the National Assembly into a constituent assembly. And then they go through the process of as if they are going to make a new constitution. Comprehensively discuss the constitution, receive memo from all over the place, and then submit the final result to a referendum by the people. That's comprehensive. So we don't know that every 5 years, every 20 or 25 years, this will happen. And then, meanwhile, we also have the piecemeal amendment when it becomes so necessary that we change a particular provision. Right now, we start a process and go through. That, perhaps, that's what I will go for. In that case, perhaps we may not need the multi-party democracy commission, but then still, from your explanation, the multi-democracy commission may become relevant not just for amending the constitution, but to do other things which the electoral commission has been not to be able to do. So yes, the process can be put in place to ensure a regular, comprehensive amendment, and then also the ongoing amendment processes for selected provisions. Thank you.
Thank you very much. I believe the first set of questions have been answered. There is a question from one of our online participants, and that's Dr. Mrs. Nana Asantua Fajinu. And she says, I have a question on the proposal presented for the Constitutional Commission to review our Constitution regularly. Can we use the Law Reform Commission to coordinate the regular reviews to prevent the usual challenges we have with having to resource yet another constitutional body? Prof, would you like to respond to that?
I believe that's what we have already been talking about. The Law Reform Commission perhaps could serve as a collating body For instance, if my organization has a concern with the constitution we want amended, we can address it to the Law Reform Commission. But then at the end of the day, what happens to all those collected proposals? That is where this idea of having a body
The multi-party.
specifically provided for in the Constitution, so that after, say, 20 years, all those ideas could be put before, through that process for a comprehensive review, or if it needs immediate attention, then it is a process through the narrow approach. I think that takes care of. Yes, right. The Law Reform Commission could be like the institution that could be used perhaps if we don't have the proposed
The Multi-Party Democracy Commission.
Right. But remember, the Multi-Party Democracy Commission, exactly, will have
other functions.
Equally important functions. Yes.
Okay. Thank you very much. Before we take our next set of questions, Reverend Dr. Emmanuel Ansah wants to make a little clarification to the presentation by Becky.
I'm not sure where that came from, but just information. You know, I think one of the panelists mentioned about Nkrumah's time, the country's regions we had. Since it's a forum for education, I thought we should make it known. It was not until the PNDC, NDC, early NDC era that we had the 10 regions. Until 1970 thereabout, we probably had 8 regions. In fact, at independence, we probably had 6 or 7. Ashanti was divided into Brong Ahafo and Ashanti. Then later on, Eastern region, Greater Accra didn't exist when I was a little boy. It came to pass, Greater Accra came in Kutua Champon's era. Yeah. Then we also have Upper East and Upper West, which actually Upper region came out of the North, the then Northern region at the time of independence. So later on, then we had the Upper West also created. And in the last few years, we've had the 6 other regions. So just by way of information, but also specifically on the subject of the women's issue. At that time, it was based on the regions. After the main election, then there was something like, I don't know, what do you call it? What they have in America after the election. No, not midterm election. They have this, no, they have some people who go to electoral college. Yes, something like an electoral college. And they go and vote on behalf of the different regions. So it's only women who contest. So they say Northern region, 3 or 4 women will contest. And they gave them a quota. Say Northern region, you have 2 women to come to parliament. Ashanti, because of the numbers. Greater Accra, because of the numbers. You are entitled to 3 seats for women. Something like that. That's the kind of understanding I think I had about the way it was run. So it can be worked out. If when we decide where there's a will, there will be a way. So it's not as if the main election, they will say that maybe no man should contest. That's not how it's going to be. The main election will take place, and after that, they will have this quota given to women. Say, okay, 30 seats are for women. They will do it proportionately in the regions. Say, Accra may have 5, Volta may have 4, so and so will have 2, then they will vote. And all the contestants will only be women. That's how it's done in other jurisdictions. So it's not an impossible task, my brother. Thank you.
Really, in certain cases, the voters will be women. The voters will be women.
So is this similar to the mixed member proportional representation?
Okay, the mixed member proportional representation would better take care of the problem. So I will just explain to you the difference between the proportional representation proper and the mixed member proportional representation. Now, pardon? You always want to be boss. Okay, so the proportional representation itself, okay, each party in the country goes into an election and they get seats in the parliament which is proportional to the percentage of votes they got. Now, so NTC, MPP, CPP go into the elections. The CPP gets 15% of the votes. The CPP will get 15% of the 272 seats in the Ghana Parliament. Okay, now, as she's proposed, this is very good for improving women's position in politics, because in those countries, there is a law which mandates the political parties to ensure that when you present a list of candidates, make sure one man, one woman, one man, one woman, and so on and so forth, so that it doesn't happen that one party will present a list which has 75% men. So the proportional representation in itself is good for enhancing the position of women in governance. Now, the mixed member proportional representation is even better. In the mixed member proportional representation, this is what happens. There's parliament. You divide the seats in parliament into two. If you have 100 seats, you divide them into two. You don't have to divide them equally. You can say that 60% of the seats in parliament, everybody can contest. But the 40%, only women candidates can contest. It is like running a 100 meters race. You put one of the competitors 40 meters ahead. A huge advantage. So if you reserve 40% of the to be contested only by women candidates, whether they are from MPP or NDC, they'll contest. But the 40% of the seats only for women. But the 60%, everybody, whether you are a man, woman, or in between, you can contest. What it means is that we offer the women a huge advantage even before the election takes place. Even before the results come out, we know that 40% at least minimum. The good thing about the proportional representation is that you can adjust it with time. If you started with 10% for women, if conditions improve, now we want to do 20%. Next time we want to do 30%. And then you decide where you want to stop. So the mixed member proportional representation, just like proportional representation, has lots of opportunities for women to improve themselves in politics. But generally, I agree with her point. The proportional representation is the best way to go. All those countries that have done very well, that is how they went.
Can I just add?
Thank you.
Oh, please let's appreciate Professor Jonah. Thank you. And yes, so thanks for the correction. So yes, so from the 10 region special seats, but then just to add to what Professor Jonah said, so if we want electoral reforms, that's why we need the constitutional quotas, because if we had at least a constitutional quota for women in the constitution, that could inform the electoral reforms, whether we want to move from first past the post to mixed proportional or proportional representation. Now, my concern with the special seats method, if it's just solely special seats, is if you read the African Barometer Report 2024, it was talking about women's political participation, international idea. It was talking about, if you look at Uganda, they have the special seats for women, and then they have the open seats where everyone can contest. And in their research, they found out that the women that were who went through the special seats were treated as inferior by their counterparts in parliament. And more so, when they tried to vie for the open seats, they were attacked. And the same thing is happening even with Kenya that has special seats. But that's not to say that that's not a good idea, but we would also have to brace ourselves for the fact that there could be backlash with if we do just purely special seats, because then they will be treated as you didn't get, like someone rightly said, secondary, you'll be a secondary MP. I don't think anyone wants to be a secondary MP, and all of that. But then it's good that we start with special seats like Prof is advocating. When we start with special seats, as it happened in 1960, when people see the women working, eventually we're going to break away from that mold where we just have it being exclusively having men in leadership. So that's just what I wanted to add, that even with proportional representation in all these places, they had the quotas. That's how come they could have proportional representation. So there are cases. Let's amend our constitution to have quotas for parliament and local government. Then that can inform electoral reforms and we can have proportional representation. So thank you.
Right. Thank you very much, Becky. I think we'll take 2 more sets of questions and then we'll wrap up. Yes, can you please pass on the microphone? There were some questions from the first set. So the gentleman over there, and then you in the glasses, and then the lady who's raised her hand. And so we'll do the 3, and then we'll get back to the last set of questions. So the gentleman in the corner. I don't think your microphone is on.
Hello. My name is Ishmael. I work with Ghana Web. I have 2 questions for Prof. So Prof mentioned that he's not so positive. This government can complete the review process before it leaves office. But in case they do, let's say by 2027, when will we see the effect? When will the implementation start? For instance, is it possible for the president to go for a 5th term after the implementation is completed, maybe by 2027? And then the second question is, even though the requirement for the entrenched provision for presidential term limit, which is 2 years, was not proposed to be amended by the committee, there are some claims that it is possible for the president to do something about it. Let's say go for a 3rd term. Is that possible?
Right. We'll pick the last question.
Okay. So if I'm correct, from what I read from the review, the report of the committee, the proposal does not include the change in the presidential term limit, which is 2 years. But some people are saying that because of 2 terms, yes, 2 terms. But some are saying that because of the introduction of semi-entrenched provisions, it's possible for the president to do something to go for a 3rd term. So is that the case?
Right. So we'll pick. There's a lady behind. Prof would respond to that. Let's pick.
Okay. If you look at new legislation, normally it may tell you when it will come into effect. So if we want to avoid that situation, they give the start time, and then that's it. That takes care of it. To avoid any confusion, you can just say this provision, this legislation takes effect from so and so date. Then that takes care of it. Sorry? No, it's a proposal. It's not law yet. Assuming the Article 291 is amended, then now a bill on that provision would now go to Parliament for Parliament to debate it. They may even throw it out. Parliament will say, no, we are not approving, we are not passing it. And then it stays there. But assuming they say, okay, yeah, let's go to 5 years. Then it will now become a new law being made by Parliament. And then the start date could be put in there. So it has to be avoided.
Okay. So that is the constitutional law answer. Now the political science answer. The president himself on more than one occasion has said he's not interested in a third term. The party, General Secretary Fifi Kwete has come out that the party is not interested in pursuing a third term agenda. Now, so constitutionally, depending upon the effective date, maybe it will be possible. But talking as a political scientist, if somebody who is a president gives his commitment that I don't want a third term, I expect that person to keep his word. Thank you.
Okay, right. Thank you. So we'll take a question. Yes, the lady with the microphone, and then the gentleman in the gray outfit.
Thank you very much. It's not particularly a question, it's a contribution.
Right.
I'd like to commend Becky.
Your name and organization.
Okay, my name is Demakwa Anaglata. I work with NetRight. I'd like to commend Becky for her response to the question our gentleman posed concerning women and their leadership. I'd like to say that fundamentally, the problems we are plagued with as society are because we are not empathetic enough. If you put yourself in the shoes of the people who are marginalized, there are so many ways you think about things differently. I don't think anyone who is going to poison someone would taste the poison before putting it into the food or the water of the person. This is a situation whereby you have a sister, you have a mother, you have a colleague, like Becky said, and you have invested so much, and then at the end of the day, you tell the person that, no, this space is too tight. You cannot fit in. So one thing I want us to look at is grassroots involvement. I think one person mentioned that women form the majority, and then if any day we want a president, we can always get one who is female. But here's the situation where majority live in rural areas. And with rural areas, you understand that access to information and resources is very limited. And we have couched society in such a way that we think that men are the only ones who are good enough. If you look at the space program in the US back in the 1960s, we have one lady called Katherine Johnson, who was very instrumental in the space program at the time. So we may not know exactly what we may be missing out on if we take women out, because we have the resources, we have the capacity. But yes, again, there are systemic issues. Economic justice is a major problem for women, and women are unable to access education to a higher level due to financial constraints. I think someone mentioned having a fund for women when it comes to quotas and how they can get into positions of power. But look at the DV fund, for instance. How effective has it been? So the thing is, address the systemic issues. Look at how women can also make money for themselves and compete as an equal playing field. And I want to just say this. You can take comfort from anyone if you have a toothache, for instance. But from the person who has equally had a toothache, you will take the comfort like, thank you very much. You really know what I'm going through. So this is not a situation of saying, this is how it has been from the beginning. Men are always supposed to be in charge and women at the bottom. We work side by side. Without each other, we are nothing. For instance, if you have someone with a disability, unfortunately, when one leg is shorter than the other, what do? The soles of their shoes are never equally made. One is thicker than the other. So these are some of the things that we really, really need to look into. You may think that, okay, the men have the capacity or the capability, but let's look at women we may lose out on in the midst of all these things. Thank you.
Right, that's an emotional submission right there. Thank you so much. I think that by the powers vested in me, I need to manage the time. And so we'll take the last couple of questions. The gentleman in the spectacles, the gray outfit, please, could you rise? And then you would give us the last question before we go on to the way forward.
All right, thank you. My name is Godwin. I'm from the Youth Bridge Foundation. Mine is not really a question, it's a contribution. As everybody is talking about women and representation, I want to talk about the youth, because we are a youth organization. We are based in youth empowerment. So as the current constitution per se in youth representation, we see a very gaps in terms of engaging youth in policy decision making. For example, currently for youth, elected as an MP, you should be at the age of 21, which is also very important. And also, as to be elected or to serve as also to participate in election is 18 years, and also to be a president, I think it used to be 40, and currently, as the review is going, they are proposing down to be 30 years.
It's still a proposal.
Yes, it's a proposal which wants to be 30 years, and we still see it as a restriction in terms of youth representation. So, for instance, how many presidents have run for their first term and they win election? So imagine somebody being 30 years, will stand for election and they didn't win. The next time the person will stand, the person will be more than 30 years, so that will be around 34, 35 years, which will not be a youth anymore. And a youth is between 35 and below. So this as a challenge. And also, for you to be elected as an MP, that means it's possible for you to serve as a council member, was in the Council of State. Yeah, so for you to be, so you can be represented as a Council of State, if I'm right, and from there you can also be as a president, because if the president is not around, the vice president is not around, the speaker is not around, that means the Council of State has to elect one of them. Chief Justice is not around, that means the Council of State has to elect one of them to be as the president. And if they are being elected, or they are being elected as a member of parliament, a youth can be a member of the council. And that one, it can also be as such a way that the person would be elected as a president at that stage. And if that's happened, because of the age restriction, the person will not be able to assume that position. So we see it as a way of restriction in terms of youth representation. So this is also something that the youth, we think is not completely eliminated in terms of the restriction of youth participation in decision making. And also, as this recommendation is being made, it's very important we should make that if it's been wrapped up to elect us, Prof. already said. Thank you.
All right, thank you very much. The last question from, yes.
Thank you very much. My name is Alfred Sidweji. I'm from NALAC, the president of NALAC. I think in the earlier submission, I overheard we proposing an independent amendment body. Is that the case? I think IDEC.
Yes.
Yeah, so this is where my question starts. We are living in a country that we all, excuse my word, behave like ostriches. We see white and we say it's black. That is the reality. Are you saying we are all? I say yes. I say respectfully. We're living in a country that we pretend not to see what the reality is. I'm saying this at the backdrop that, or the question is that, are we assuming that independence, as you put it, will be immune to political influence? That is my question. Because I'm saying this at the backdrop that we are living in a country that we all know that even our sacred societies are not spared from politicization. We know this is an NDC pastor. This is an MPP pastor. This is an NDC or Confor. We are all aware in this country. So if you say we are putting up this independent amendment body, how that the politician will not permeate through that? Because even our sacred society, they're able to do that. Because one, those members who will feel how do we call it, the independent amendment, they are human beings.
You have
and they are also
seconds.
Ghanaians. Thank you very much. That's my question.
Thank you. Yes, that was a contribution, right? Yes. And so on that note, I think I would ask yes, you must.
Okay, so you elected to put the emphasis on the independence. We at IDEC are more interested in the function. That is, every few years or so, we are raising this question of constitutional reform and so on and so forth. Can we get a body, technically sound body, constitutional, to perform that function. As to the question of independence and so on and so forth, you can do your very best. Like the National Media Commission says, this institution should bring up. You can adopt a formula like this. Quite frankly, there's no way in which you can avoid somebody from NDC or NPP coming through that. You can't. But you do your very best. The main emphasis is to get a technically sound body that will take charge of the process to ensure that the process does not get truncated as it has been done in the past. That is where our emphasis is. Thank you.
Thank you very much. Time is fast spent.
Just to say a little bit to our youth about the Council of State. There is, no matter how you look at it, there's something to say for the gray hair. When we talk of Council of State, they are like the Council of Elders. And it takes some little bit of experience, going through the knocks of life to get some little bit of experience which you can put at the disposal of the president to guide the nation. Now, if you're talking of a youth of 21, what experience is there for him or her to put at the disposal of the president in guiding this nation? So it's not just a matter of going to debate. You are there to put your experience at the disposal of the state. So if you are there as a former Chief Justice, you must have gone through a lot to be there. The former Chief of Defense Staff, you must have the former IGP. So that is the idea of the Council of State. So in certain cases at least, we have to give some room for experience. Thank you.
Thank you very much, Prof. And I believe in expertise as well, not just experience, but expertise as well. Thank you very much to our panelists. We've come to that point in our program for reflections and way forward. And I would like to call on my Executive Director, Dr. Emmanuel Akwete, to give us, on the program, we have you for reflections and way forward. Or maybe just share some thoughts with us on the program.
On campus, we used to call this communist inferior tactics. I thought it's past, but I'm surprised it's still active. I thank you all for coming. I think what I've observed is that the issue of the Constitution and the reforms that are needed are still very much alive. And I think more of this is needed, given that the President said yesterday when he met the NGOs and CSOs that they are working on the CRC report, and that means that maybe we will be seeing some implementation, given what the history has been. A lot of constitutional reviews that never see the real actions in terms of implementation. So there's work for us to do. For us, this is to start it, and we want everybody to engage. It's a citizen thing. I think they are publishing, I hear it's about 700 plus. Pardon? 680 now, okay. But I think from today, what you've learned, we would assume that you're all going out there actually interested in the subject, reading and engaging and informing others in our communities. Because we all have the vote at the age that makes us eligible. But we have taken too long to go through constitutional amendment in the country. And yet we need some changes. My own position is I do not know whether it's a matter of a large number of amendments that will make it effective. But we once had two professors, world-class professors known. They worked at the University of Ghana, and they set it up. Professor Fraser, the late Professor Griffiths, and the late Professor Jando. In 2014, we had a similar event. And what they said was that wholesale reform of constitutions could be riskier because every article in the Constitution, once amended, or if we are considering amendment, we should also think of the fact that it is going to have a knock-on effect. And that may not be obvious all the time. Even the analysis might not put it up until people start raising questions and so on. So we can learn from the US and others how well they have operated within the existing constitution of 100 years old and so on, and yet it's moving on. I think we were told they had a very limited number of articles, is it 100 or less? We seem to be increasing our articles. I think we should all get involved in asking those questions. But the future really, as I stand here, I see the youth. Tomorrow is yours, you are the leaders and so on. But I think you should get involved in these constitutional conversations and see not only what Ghana needs, but what has worked in other places. I like hearing about Kenya. I just came from Kenya last week, Friday. And they were looking at democracy, they were looking at the Kenyan experience. You would know that Kenya had some very deeply rooted ethnic politics and violence that came in the parties and so on. Then a new constitution came up after so many people were killed, and it was quite horrible. But they are telling a different story now. The new constitution was promulgated in 2010. And so it's about 15 years. But young Kenyans, as I sat in the meeting, think differently from those I knew when I used to go there before the 2010 events. And so a nation, a sense of a nation, a sense of responsibility of leadership of a high quality was a conversation that was taking place amongst the youth. So amendment of the Constitution is important, but we have to look at it critically. Is it the numbers? Is it everything that must go in? What is it that will transform the nation we want to build? And you are the future leaders. Prof taught me, when he's talking to me, you can tell he was my professor, isn't it? The two professors. But I tell you, it's your generation. And I think don't look at only Ghana. I would urge you to look at what Kenya went through and what Kenya is now becoming. You are the future leaders, but constitutional rule is extremely important for all of us here to have the opportunity to bring about changes that will make Ghana stronger and the new generation to follow you to continue with the good work. This is what I'll say. It's the beginning of an exercise that I think will go on for a while. We have plans. Most of the articles in the CRC report will be handled by Parliament, and it needs massive education. MPs and their constituents ought to know what these things are about. And we have a very youthful generation now, university, those who have graduated, those who are students and so on. I think the new generation is in that strata, and you ought to take some very serious interest in that. We'll continue to monitor, and where we have to hold gatherings like this and invite you to come and share ideas, think through it, and see how best you can influence outcomes, that we will do. But the future really, and the new constitution or amended constitution that comes would have to be something you should take very keen interest in. Thank you very much for coming. Thanks.
Thank you very much, Dr. Akwete. Ladies and gentlemen, another round of applause for him. And before we wrap up finally, I'd like to acknowledge the presence of these media houses: Ghanaian Times, Ghana Web, TV3, 3FM, Daily Graphic, Channel 1 TV, Atinka TV and FM, Metro Television, Ghana News Agency, Joy News, Joy FM, Original TV, Original FM. We are so delighted you came to support us. Thank you very much, and we hope that as you go back, you give us a good coverage and a good report. There's a proverbial saying that Opening Jaria Nensiasa. I think there's also a dilution which says that Sopening Kasa na Semasa. And so once my boss has spoken, I think he's drawn the curtains on this program. I'd like to thank Professor Kofi Kwashiga for coming to give a good presentation and to support this program. Also to Becky Ahaji and our very own Professor Kwesi Jonah. Thank you also very much for coming. You would realize that at the registration desk, we had a QR code, and that would lead you, as you scan, to our policy briefs as well. And so let's keep the conversations going, and we're hoping to have some more dialogues in the future. Thank you very much. God bless you all. Okay, so please don't go yet. We'll have a photo op outside. Walter, are we having it outside? Yes, okay, so we can arrange the chairs very quickly. Right. Yes, we'll do that outside. So please let's assemble outside for our photo op. Guys, can we have some help with the chairs? Some chairs outside, and then we can. Where's Walter? Oh, thank you so much. We need some chairs. Sorry. All right, so please come around. Come around, let's stand behind the chairs. Ladies and gentlemen, please come around. Let's have our photo op so we can disperse very quickly.
Then you can download your transcripts in formats like PDF and Microsoft Word.
And it's free, up to 3 files every day. And if you need more, you can upgrade for unlimited transcriptions.
To get started, just visit turboscribe.ai and start transcribing for free.
Siri's dictation was driving me crazy, so I switched to Whisper mode. Here's why I'll never go back. First off, it actually gets it right. Watch what Siri does with this. Can you share the mirror